Thank you very much indeed. It's an honour and a privilege to be here. You kindly introduced me as Professor of EU Law. I tend to say I'm Professor of ex-EU Law. I'm also Professor of Employment Law, so at least I know what redundancy looks like, but we do have work for a short period of time ahead. Now, I'm going to talk a bit about what the situation is at the moment, and my very distinguished colleagues will talk about the alternatives. So, what are the implications of withdrawing? Now, as we know, withdrawal from the European Court of Justice is one of Theresa May's red lines, and we can see that in the white paper. This is a key component of taking back control. Court of Justice is the EU's ultimate arbiter on matters of EU law. As a supranational court, it aims to provide both consistent interpretation and enforcement of EU laws across all 28 member states and a clear process for dispute resolution when disagreements arise. Now, I don't think I could have put that better myself. In that white paper, you've got a very clear statement of why you need a supranational body to enforce and uphold trade agreements. Now, the white paper goes on to say, and I suspect this is what the government and the Leavers are most concerned about, the CJU is amongst the most powerful of supranational courts because of the principles of supremacy or primacy, so EU law taking precedence over national law, and also direct effect, which is about the enforceability of EU law in national courts. And without so much explaining why one thing leads to another, we have a clear statement that we will bring an end to the jurisdiction of the Court of Justice in the EU. So this terrible monster of a court, is it as bad as it's been built up to be? Well, crudely speaking, the court does three things. First of all, it interprets what EU law means. An important role because often EU law is badly drafted. Why? Because it's a product of compromise. And the way most of its interpretation is done is as a result of a case starting in a national court not knowing what an EU rule means, and then there is what's called an Article 267 reference to the Court of Justice to explain what this rather obscure might mean, and the case then comes back to the national court. Secondly, it's actually there as an enforcer of EU law. The Court of Justice is there so that when the Commission thinks that a member state is not complying with the rules of the game, the Court of Justice will be engaged under the Article 258 procedure, and the member state will be formally reprimanded. And if the member state still doesn't get its house in order, the case goes back to the court and the member state can be fined. So it's an important vehicle for ensuring that the rules of the game are actually complied with, which has always been in the UK's best interest, because generally we already comply with the rules of the game. So it's in our interest to make sure that the other sides do so as well. Third thing the court does is to rule on the validity of EU law. If EU law has been passed where the EU law there's no justification for it, there's no good explanation for it, there is no competence for the EU to act, the Court of Justice will consider that under Article 263 and will challenge it. So that just gives you in outline, actually, why the Court of Justice is important and thus supports what the UK government said, that it is very important because it ensures both consistent interpretation through the Article 267 process and also the enforcement of EU law through the Article 258 process. As I say, white paper is absolutely spot on. But that rather overlooks the practical realities. Court of Justice deals with about 1,700 cases a year, so a lot, but if you think about the fact you've got a population of 500 million across 28 member states, that is the tip of the iceberg. Most of the cases are dealt with either in the national courts or people just comply with the law because they know that if they don't comply with the law, there will be the possibility of cases being brought in the national court. And this is what this diagram is very briefly to show. This is the language of direct effect, which is what lawyers use to say about the enforceability of EU rights. EU rights, so provisions in a directive, provisions in the treaty, are enforceable in national court. So if I've been discriminated against on the grounds of my sex, and EU law is more generous to me, I can challenge that discrimination in the local court here in London or in Cambridge, and I can enforce that right in the UK courts, either against the state, if the state happens to be my employer, or against a private sector employer. Nothing to do with the ECJ. ECJ is there as an ultimate fallback. At the moment, the shadow effect of the ECJ hangs over the proceedings, but basically there's a mechanism to get EC law enforced in the British courts. Jumping ahead to what my colleagues will say, all other systems which are being considered, none of them have this possibility of enforcement in the domestic court. There's no other system apart from the EU system with direct effect in the very full form that there exists in the EU system. And also there is no other vehicle of quite the kind which allows this engagement with the Court of Justice through Article 267. So I've given you a brief summary of what the Court of Justice does and how it operates both at EU level and at national level. So we're losing that. Does there need to be something in its place? Well, for the first time, to my knowledge, in a public document, the UK government has recognised that there needs to be something else. And indeed, it's a sort of backhand compliment to the ECJ that it's already done a pretty effective job, but so effective that it's trampled over the control of the British courts. And so in the white paper, there is a clear statement that there does need to be something which replaces the Court of Justice. We recognise that ensuring a fair and equitable implementation of our future relations with the EU requires provision for dispute resolution. Dispute resolution mechanisms ensure that all parties share a single understanding of the agreement. We need to have a referee to ensure that both sides uphold the bargain, both in terms of its interpretation and application, what the Court of Justice has been doing. And the mechanisms must also ensure uniform and fair enforcement of agreements. So, what are the alternatives? The white paper offers a couple, and my colleagues will go into them in much more detail, but I'm afraid I think the white paper is scant in terms of detail about the alternatives. Dare I say, it looks rather like someone has typed into Google, what else can we do, help? And up has come the New Zealand Korea Agreement, not the first one that would spring to mind, but also various others. And they have, of course, to be fair to the government, they would say it's merely examples. But I'm afraid on this issue, which we as lawyers think is crucial, and which I hope you as economists will appreciate is crucial, and if you don't already, you will be convinced by the time we've finished speaking, that there needs to be something, and there needs to be something effective. So they talk about CETA, the Canadian Free Trade Agreement, where you've got a joint committee which supervises the implementation and application of CETA. No, nothing judicial there. An ad hoc arbitration panel. Lawyers don't like anything with the word ad hoc in front of it because there's no build-up of expertise. And there are all sorts of issues about how you appoint that arbitration panel. And then, of course, there is special provision for investor dispute settlement. And you'll hear about some of the problems about that shortly. NAFTA, there is a nice, cosy, amicable settlement of disputes. That doesn't sound very robust to anyone who's a lawyer. It's really pretty thin. So what's interesting is the white paper goes on to say the actual form of dispute resolution in a future relationship will be a matter for negotiations, and we should not be constrained by precedent. I think that's important because I think that's sending out a signal that none of the previous models are any good at all, and there needs to be something else. And answers on a postcard, can we come up with something which works better? And I think that's what this is a call for. Can an imaginative solution which doesn't involve the ECJ be dreamt up, which might satisfy all the things that the ECJ currently does. They then talk about any arrangements must be the ones that respect UK sovereignty, protect the role of our courts, and maximise legal certainty, very important. And that brings me to this. This cartoon is one I really like because it was appeared just at the time of the Miller judgment. Miller, as you recall, was the judgment which basically forced the Parliament to consider whether Article 50 should be triggered, and it took British courts to say to the British government that the British Parliament needed to be involved in the Article 50 process. But this ambivalence to the role of the British courts, which are meant to be there as the main strand of taking back control, is indeed rather striking. But anyway, the message is clear that it will be the British courts eventually which will take back control and will decide how we govern our lives and how our lives, how laws will be applied to us. But just wait a moment. There will, whatever the White Paper says, be a residual role for the Court of Justice. And it would be disingenuous to suggest that the Court of Justice will, come the 31st of March 2019, have no influence on our judicial system. And there are a couple of ways how the Court of Justice will continue to affect our day-to-day lives. First of all the case law pre-Brexit will carry on being binding. We don't quite know what form that might take, but it will certainly carry on being binding as it is at the moment, and British courts are very used to applying European Court of Justice decisions and giving them precedential value, i.e. we follow what they say, and also probably a supremacy, because we're used to saying that what the Court of Justice says on the interpretation of EU law will bind British courts. Post-Brexit, it was thought that the decisions of the Court of Justice would be merely of persuasive authority. It would be interesting to take into account what the Court of Justice says on interpreting an EU provision. However, there's a problem. One, post-Brexit case law will not have the benefit of British judges deciding the cases and British advocates arguing the cases. The common law has had a disproportionate influence on the shape of the judgments of the Court of Justice since 1973. Yes, of course, Ireland will still be there, but the UK has certainly punched above its weight, or to be precise, England and Wales have punched above their weight in terms of influence in the Court of Justice. And furthermore, if you look at the White Paper reasonably closely, it suggests actually that these judgments might have more influence than we first thought. You'll see it says, in general, the government believes that the preserved law should continue to be interpreted in the same way as it is at the moment, thus suggesting that the case law will have as much significance post-Brexit as it does now. Furthermore, there are other areas which apparently we want to opt back into, the European arrest warrant being one, which the operation of which is dependent on rulings of the Court of Justice. Because it's important to think, and this is my last slide, it's important to realise that EU rights are premised on EU remedies, and by EU remedies I mean the decisions of the Court of Justice. And this is a point which is very difficult to get away from. Finally, for you, those of you who are interested in commercial matters, some areas of EU law have what's called extraterritorial effect. In other words, they apply outside the territory of the EU. Competition merger law is a good example. Google, Microsoft have felt the wrath of the European Commission, and they have challenged the decisions of the European Commission before the Court of Justice. If there's a hard Brexit, nevertheless, EU competition law will continue to apply extraterritorially and will affect British companies, and they will want to be able to challenge any decisions that are made against them before the Court of Justice. Furthermore, I gather you've been discussing this morning the question of financial services and what might replace passporting, and whether there are determinations of equivalence. What happens if equivalence is not determined? Is that merely a policy decision, or is it a decision which has legal effects which can be challenged under Article 263. We would clearly want to be able to do that, because clearly it will have significant financial costs. So my bottom line is the Court of Justice ain't going away, whatever the UK government might say to the contrary. Thank you very much.